Hello. In the following, I would like to talk about the entry of an international application into the national phase. I would like to discuss what this is all about, the important decisions that need to be taken at that point in time, the time limits which need to be respected, and from a practical perspective, how do you best go about entering with your international application into the national phase. At the end, I would also like to refer to, well, let's call it a worst case scenario where you miss the time limit to international phase, and I would like to discuss some of the remedies which are available to you as applicants in such a situation. But let's first start with explaining a little what this is all about. The term entry into the national phase really describes a part of the PCT procedure where the applicant actively takes the international application, makes a decision where he would like to continue with this application, and takes it to those designated offices where he would like to continue with the processing of his application. It naturally flows and follows from the international phase, but it needs this active intervention by the applicant who needs to take certain steps to enter the national phase. Of course, it's also the phase where we will talk about the patent grant for the particular application. It's up to the national offices to decide whether ultimately a patent can or cannot be granted on a particular claimed invention. We do feel that it should be easier for applicants that have gone through the PCT procedure and are now entering the national phase in certain respects than applicants filing direct national application. Why is that? Because once you've gone through the PCT, a formality check has already been performed on your international application. And under the PCT, the national offices are now obliged to apply the same formality requirements as under the PCT also in the national phase. And there's only a limited set of formality requirements which they can ask for compliance with in the national phase, which haven't maybe been checked or addressed during the international phase. Also, you should come with a set of valuable reports, at least the international search report and the written opinion of the ISA, and those reports, of course, could be used if the designated offices so wish, for the processing also now in the national phase. So overall, it should be easier for PCT applicants. Entry into the national phase is also decision-making time. There are some very important decisions that need to be taken, and you need to really put some careful consideration into thinking about how and where you would like to continue with your international application. This is important because there are important cost implications with national phase entry. If you enter the national phase, you need to pay national fees to the various designated offices where you enter national phase. You need to, in many instances, hire a local patent attorney or agent that helps you with the prosecution of your application in the national phase. And you would also need to translate your application into a language accepted by the national office. And so if your PCT application is in a different language, you would need to come up with a translation. And of course, that is also an important cost factor. So entry into the national phase is, relatively speaking, expensive. And that's the reason why we feel you really need to carefully think about how to proceed. Most importantly, you need to review your initial decision that you took when you filed your international application, when you decided to file a PCT application. You need to review that decision and think about, do I still need patent protection in those countries where originally I thought I would need patent protection in? And this could have changed over the life cycle of the international application, from the filing of the PCT up to the time limit now when you're entering the national phase. So do review that initial decision. And some of the things you need to think about is, for instance, the big question whether you want to continue at all or whether you might prefer to drop your international application at this stage. this could have something to do with the question of whether you think, based on the international reports that you received, it is likely or extremely unlikely that a patent will eventually be granted on your claimed invention. If it's extremely unlikely, you might decide at this stage to not continue with the process. But it's not only a question of whether your invention is or is not patentable ultimately, and in which form it might be patentable, but it's also a business decision. Do you really need protection of your invention in a particular country? And ultimately, as a business decision, it all depends whether you can expect to generate some income, you can expect some return for your investment that you're making with having filed your patent application, and also, of course, now with the costs in the national phase. If you can't really reasonably expect much return, getting a patent as a wall decoration is one thing, but it might not really be worth the expenditure that you have at this point in time. And if you realize maybe the markets have changed, maybe your invention isn't as, economically speaking, important as you originally thought, well, maybe at this stage you could also decide, no, I'm not going to continue spending extra money on this particular application. A related question, of course, is where to enter the national phase. And of course, here you have the choice. You file your PCT application designating automatically all states. And now you really need to pin it down and decide, I want to enter the national phase before such and such countries. Of course, you probably had something in mind originally, but again, review that decision because things might have changed. A country which you thought was very important for you is now not so important because of certain changes in the market. Or you realize that maybe this is not the big invention that you thought originally and you need patent protection in many countries. Well, maybe it's only a smaller invention and then patent protection is only needed in fewer countries than originally thought of. When to enter national phase is another decision you need to take. The PCT guarantees you a minimum time limit of 30 months from the priority date to enter the national phase. In some cases, however, national offices allow you a longer time limit, namely a 31-month time limit. And some offices, if you pay a small additional fee, actually give you even further time to enter the national phase. So this is the maximum. However, you don't need to always wait until the expiration of 30 months to enter national phase. You could also decide to enter national phase early. This is completely permissible. Even one day after the filing of your PCT, you could already enter the national phase. Would be relatively unusual, but it's possible. And you also don't have to do the same thing for each and every designated office where you want to continue. You could decide in one country you want to enter national phase earlier because you know there's a competitor out there and you want to get a patent quickly to stop him from potentially infringing your patent rights. And in the other countries you seem to have a little more time, so there you wait it out until the end of the 30-month time period. One thing generally to keep in mind is that any delays during the international phase, like a late search report, a late IPRP Chapter 2 out of the Chapter 2 procedure, that does not extend the time limit for you to enter national phase. The time limit to enter national phase is calculated based on the priority date, and that is more or less cast in stone because that's either the international filing date or the earliest priority date that you have in your PCT application, the filing date of your earliest priority claim that you're making in your PCT. If you do have an issue that you come to the end of the 30-month period and you realize it's too early for you to enter national phase, there's one radical thing that you could possibly do to extend the time period to enter national phase, and that would be to withdraw your earliest priority claim. Now that's formally speaking relatively easy to do, but of course it has important and serious substantive considerations or implications. If you withdraw your priority claim, you're not protected against any intervening prior art in the priority period anymore. So unless you're really sure that there's no important intervening prior art and that you don't really need your priority claim, be extremely careful about withdrawing your priority claim. If you are, however, in a position where you realize you know the prior art out there, you know there is most likely no intervening prior art in the priority interval, then this could be a radical decision to take, and that would then extend the time limit to enter national phase by up to 1 year, depending on your priority claim that you're withdrawing. Another last choice that you could be making is to decide with what you're actually going to enter the national phase. With this I mean that if you enter the national phase and you don't say anything, you will ask for patent protection. But there are other types of protection that an applicant under the PCT can ask for, in particular designated offices. Let's take the example of China. In China you can either continue with a patent application or with a utility model. This is a choice that you need to make, you need to decide, and at the time you enter national phase, you need to tell the designated office which way you would like to go. If you want a utility model, tell the office so, check the box in the form, for instance, that exists, or use the appropriate form to indicate to the office, I would like to continue with a utility model application. Again, if you don't indicate anything, the default will be you will continue with a patent application. So now that we decided to enter national phase, how do you go about best entering the national phase? You need to keep in mind there are two really important requirements that you need to meet within the 30-month time limit that applies for entry into the national phase. And that is, you need to furnish a translation of your international application. The language of filing is not a language accepted by the national office, and you need to pay the national fees. If you've complied with those two requirements, you are, so to speak, in the national phase and you can continue the processing before that particular designated office. But you, as an applicant, you actively need to take at least these two steps to enter the national phase. There's a third requirement which applies in rare situations where you enter the national phase early and your international application has not been published at that stage. In this case, there are some designated offices which would require that you furnish to them, together with the translation and the payment of the fee, a copy of the international application as originally filed, because they can't yet get a copy from us because we haven't not yet published your international application. Remember, if you do not comply with these requirements, your application will be considered withdrawn before all those designated offices where you did not take those important steps within the applicable time limit. Now, once you've taken those steps, there are a few other requirements that you need to comply with, and they are generally referred to as special requirements under Rule 51 bis of the PCT. What kind of requirements are we talking about? Well, for instance, for the USPTO, you would have to furnish an oath or declaration of inventorship. For certain countries where the inventors do not enter national phase, but it's a corporate applicant entering the national phase, national law requires that an assignment document is furnished which shows that there's a transfer of rights from the inventor to the applicant. Do note that these two requirements you could also comply with when you file a declaration referred to in 417. So you could do these things up front and you wouldn't have to do them now when you enter the national phase. One thing that you probably will have to do in many instances is appoint a local agent to allow you to prosecute your application before the national office. Offices could also require that you furnish translations and other documents in more than one copy. That would also be such a special requirement under Rule 51 bis. Offices can also require you to translate the priority document. Now, there's one important limitation. Offices shouldn't routinely ask you for a translation of the priority document. In fact, they should only ask for translation if the validity of the priority is relevant to the determination whether a patent can or cannot be granted. So this means in practice, if there's no intervening prior art between the filing date of your priority application and your PCT application, and thus it does not really matter whether you make that priority claim and whether that priority claim is valid or not, in those cases they should not ask for a translation of the priority document. If the case is different, then they're entitled to ask for a translation. Note also there's another exception or another area where offices could ask for a translation, and that is where during the international phase you relied on incorporation by reference of a missing element or part, by showing to the receiving office that something was already in the priority document and you're pulling it into your PCT application. Makes sense that in this case also the national office can verify this decision, and for that they would need a translation of the priority document. But these are the two exceptions. Now, the time limit to comply with those special requirements that I just referred to, at least most of them, is 2 months from the effective date when you're entering the national phase. So if you're entering national phase early, of course it's from that date, or otherwise from the 30-month time limit when you're entering the national phase. Be careful, however, sometimes you are of course entitled to use that additional time, but offices are also entitled to charge a late furnishing, late payment fee in some of the instances where you come in late with some of the other special requirements that I just talked about. Now, we do hope that entering the national phase should be easier than filing direct national applications, as I said at the outset. And one of the examples for this, for instance, is that you have already during the international phase furnished an original priority document. What happens is we make then copies and we furnish that or make it available to the designated offices. As a result, you as the applicant, you only have to ever furnish a single original certified copy, and the national offices should not ask you for another original certified copy. That should really be a simplification for applicants. If you do not have any text matter in drawings, that's what we generally recommend, a simple copy of the drawing should in most cases be sufficient. However, if there is text matter in drawings, then you need to always remember to also translate the text matter into the accepted language of the national office and to not overlook to furnish that translation. It's also good to know that in general, your international application, when it's translated, doesn't need to be in form of a certified or legalized translation. In most cases, a simple translation is absolutely sufficient. Some offices, however, require what we call a verified translation. A verified translation is basically where the person who translated the text undersigns saying that he or she translated this to the best of his or her knowledge. It's simpler than a legalized translation, and so it's good to know that legalized translations in principle are not required, and offices can also not require it. There's one exception. If you're in the national phase and the examiner at the national office has some doubts about the correctness and the completeness maybe of your translation, in this case, subject to an express invitation from the examiner at the national office, they can now ask for a legalized translation to prove that your originally furnished translation was really an accurate and complete translation. The PCT actually also says that national offices can in principle not require you to use a particular form to enter national phase. This was really put into the PCT to ensure that an applicant who might not have access to a particular form could still manage to validly enter the national phase and to not miss the time limit to do so. However, many offices do provide forms specifically for national phase entry, and our recommendation is if you have access to the form, by all means use those forms. It makes your life easier, you know exactly what you need to furnish, and it's a clear indication to the national office that you're entering the national phase following the PCT procedure. Some practical suggestions that we would also like to make. I think the most important one is that you really should leave yourself sufficient time to effect the national phase entry. Don't take the decision at the very end of the 30-month period and rush into the national phase. The biggest problem here is that you need to come up with probably several different translations, and that might be very difficult to accomplish in a short time frame. So ideally, you really leave yourself sufficient time to decide where you want to continue. Of course, if you want to continue first of all, and then you can prepare for national phase entry. Keep also in mind that you really need to thoroughly inform your local agents how you wish them to prosecute the international application in the national phase. In which direction should they argue the case with the national examiner? Should they file any amendments, maybe amendments of the claims to avoid certain claims fees? All of this needs to be communicated to your local agent, and of course he also needs to be well informed about what has already happened during the international phase. As a reminder, the applicant really is responsible for monitoring the time limit to international phase. There's only one office out there which issues a reminder to applicants that it's about time to international phase, and that's the European Patent Office. They will send you a notice before the expiration of 31 months from the priority date that it's time to international phase before the EPO. Well, that works well with the EPO because a lot of applicants do enter the national phase, but maybe it's a good thing that not all our contracting states issues such reminders, because clearly not, or an applicant does not enter the national phase before all the designated states. Make it clear to the national office that you're entering the national phase, that you're not filing a direct national application. And be careful that your translation is as complete and as accurate as can be. If your translators, when they're translating your application, notice that there's something wrong in the original, they should bring that to your attention. They should still translate accurately with the mistake that they've noticed, and then it's up to you to try to address whatever is wrong in your application through the applicable procedures before the national office. But the translation should never be better than the original, because if it is, it could come to a decision by the national office. This is not an exact translation, therefore the application cannot be accepted in the national phase. So hopefully by now you are successfully in the national phase. But how about those cases where the worst does happen and you miss the time limit to enter national phase? There is a provision in the PCT, Rule 49.6, which can help you in these instances. Before that rule was introduced, the PCT basically just had an opening clause saying designated offices are free to still accept applications where the time limit has been missed, but they weren't obliged to do so. Now, this wasn't considered satisfactory, and the member states adopted a rule which basically now obliges offices to give the applicant an opportunity to reinstate their application in such a case. Do keep, however, in mind that when this rule was adopted, some offices could not yet accept this provision and had to make a reservation. They notified us that it was incompatible with their national law and they needed more time to modify their national law. If you're interested in entering the national phase before an office which has made such a reservation, and you find information about that on our website and in particular also in the PCT Applicants Guide, I would recommend that you check for details on what procedures might nevertheless exist before a particular office in the Applicants Guide. Because even if they don't apply 49.6, there might be some other provisions under their national law which could help you. Take the example of Canada. Canada actually made a reservation and does not apply 49.6. However, if you pay a relatively small additional fee, even after you miss the time limit, you can still pay that fee. You get an automatic extension without any further explanation of up to a year from the Canadian office, possibly even more. If you are entering the national phase before an office which does apply 49.6, then basically you need to explain to the office why you have missed the time limit to enter national phase. And there are two possible explanations, and the offices can choose which one of the two explanations they would accept. They could either accept unintentional, you missed the time limit unintentionally, or you missed it in spite of due care. They need to apply one of the two criteria, not both of them necessarily, but at least one of them. And again, in the Applicant's Guide, you would find the details as to which criteria which office applies. The time limit to request reinstatement is 2 months from the removal of the cause, the reason why you missed the time limit to enter national phase, or 12 months from when you should have entered the national phase, whichever time period expires earlier. So the longest is 12 months, but it could be as short as 2 months, and therefore you do not have so much time to request reinstatement of your international application. Do note, however, that designated offices are entitled to apply longer time limits. So it's just a minimum time limit, minimum standard under the PCT, and offices are free to be more liberal than this minimum standard. So I hope in this presentation you were able to get an overview of what you need to do to successfully enter the national phase with your international application. I highlighted that it's extremely important to take some careful decisions at this point in time because also of the cost implications associated with the national phase entry. I did cover some key issues to remember when entering the national phase and what you need to comply with to successfully enter the national phase. And at the end, I also referred to those cases where unfortunately you have missed the time limit to international phase, and I described some of the remedies which are available to you to even help you in those kind of situations.